Namaste everyone. Welcome to Courts This Week on Live Law. I am Tanya Pandey and every week I'm here with the most recent court updates from across the country. Subscribe to Live Law to continue receiving legal updates and click the bell icon to not miss any videos from us. We'll begin the episode with judgments from the Supreme Court and then cover High Courts and other courts. The Supreme Court on 11th July sentenced fugitive liquor baron Vijay Mallya to 4 months imprisonment and a fine of Rs 2,000 for contempt of court. Mallya was found guilty in 2017 for transferring $40 million to his children in violation of the orders passed in a case filed by a consortium of banks led by the State Bank of India. The court, while pronouncing the sentence, said that Mallya did not show any remorse for his conduct and did not appear before it during the sentence hearing. The court added that adequate sentence must be imposed on him to uphold the majesty of law, and that directions need to be issued to ensure that the amount in dispute is available for execution of the orders. The court has accordingly directed Mallya to deposit $40 million with 8% interest within 4 weeks with the concerned recovery officer, failing which attachment proceedings will be initiated against his properties. The Supreme Court on 13th July held that when the Juvenile Justice Board does not comprise of a practicing professional with a degree in child psychology or child psychiatry, it would be obligated to take assistance of experienced psychologists or psychosocial workers or other experts under proviso to Section 15(1) of the Juvenile Justice, Care and Protection of Children Act 2015. Initially, all children below the age of 18 years were to be treated as juvenile and tried by the board. Only after the 2015 Act came into force, a separate category of juveniles between age 16 to 18 years involved in heinous crime was culled out, who were subjected to a preliminary assessment to ascertain if they are to be tried as a child by the board or as an adult by the Children's Court under Section 15 of the Act. A bench of Justices Dinesh Maheshwari and Vikram Nath noted that the preliminary assessment under Section 15 of the Act is a delicate task and appropriate and specific guidelines would be required for the same. The Supreme Court has observed that it is not mandatory for the adjudicating authority to admit an application to initiate corporate insolvency resolution process, even if a debt existed and the corporate debtor is in default. However, such discretionary power cannot be exercised arbitrarily or capriciously, the bench of Justices Indira Banerjee and J.K. Maheshwari cautioned. The court observed that ordinarily the adjudicating authority, that is NCLT, would have to exercise its discretion to admit and initiate CIRP on satisfaction of the existence of a financial debt and default on the part of the corporate debtor in payment of the debt, unless there are good reasons not to admit the petition. The Supreme Court on 14 July held that it is not open for High Courts to implead third parties in exercise of powers under Section 438 of the Code of Criminal Procedure, which deals with anticipatory bail. In a plea assailing interim orders of the Patna High Court, which had issued notice seeking appearance of Sahara Chief Subrat Roy in anticipatory bail proceedings of one Pramod Kumar Saini and co-accused, a bench of Justices A.M. Khanvilkar and J.B. Pardiwala held that it is not open to the High Court in exercise of powers under Section 438 CRPC to add third parties to the proceedings, as if it is invoking powers under Order 1 Rule 10 of CPC, much less those parties who are neither necessary nor proper parties to the application under consideration. The bench clarified that the scope of inquiry of the High Court is quite narrow in an anticipatory bail application under Section 438 CRPC. The Supreme Court on 14 July held that in petitions seeking writ of habeas corpus in matters relating to custody of child, the court exercises its inherent jurisdiction, independent of any statute, and therein the paramount consideration of the court is to ascertain what is in the best interest of the child. A bench of Justices A.M. Khanvilkar and J.B. Pardiwala allowed but issued certain directions in a plea filed by a mother seeking the apex court to issue writ in the nature of habeas corpus and to issue directions to the state authorities to trace her 2 minor children and deliver their custody to her so that they can be repatriated to the United States in compliance with the order dated 30th July 2021 passed by a court in Ohio, USA. Let us now go over judgments from the High Courts and other courts. The Delhi High Court has refused interim relief to a 25-year-old unmarried woman seeking termination of a pregnancy of 23 weeks and 5 days. The court observed that an unmarried woman whose pregnancy arises out of a consensual relationship is clearly not covered by any of the clauses under the Medical Termination of Pregnancy Rules 2003. The Medical Termination of Pregnancy Rules, as amended in 2021, provides the category of women whose pregnancy above the age of 20 weeks can be lawfully terminated. A division bench of Chief Justice Satish Chandra Sharma and Justice Subramanian Prasad said that an unmarried woman who is pregnant out of a consensual relationship is not specified among those categories and observed that at this point they cannot go beyond Rule 3(b) of the rules. The Jammu and Kashmir and Ladakh High Court on 16 July dismissed an appeal filed by an accused in the 2019 Pulwama terror attack, claiming that he was a juvenile at the time of the alleged offence. While dismissing his appeal against an order of a special NIA court, a division bench of Justices Rajneesh Oswal and Mohan Lal observed that the court had no hesitation to hold that the appellant was more than 18 years of age and was not a juvenile at the time of commission of the offence. The court observed that the VBID blast took place on 14 February 2019 at Lakepura, Pulwama, was the ultimate result of a conspiracy of which the appellant had been alleged to be a partner, and he is equally responsible for the said illegal act. The Bombay High Court has held that a child in conflict with law, as per the Juvenile Justice, Care and Protection of Children Act 2015, can file an application under Section 438 of CRPC seeking anticipatory bail. A division bench of Justices Sarang Kotwal and Bharat Deshpande opined that a plain reading of Article 14 of the Constitution of India would show that any protection which is available to any person under the law is available also to a child as defined under the Juvenile Justice Act. The provisions of Section 438 of CRPC afford the earliest protection during or even investigation, and therefore even a child in conflict with law has a right to use this remedy. The Karnataka High Court on 15 July rejected the application filed by Alliance of Digital India Foundation challenging the maintainability of Google India's plea to restrain the Competition Commission of India, CCI, from divulging the company's confidential information to the complainant Alliance. A single-judge bench of Justice S.G. Pandit further extended the interim order passed earlier, restraining the Commission from divulging the information of the company available with it, and directed the respondent to file its objections to the petition within 2 weeks. The Telangana High Court has overturned a POCSO conviction as the age of the victim girl could be above 18 years of age on applying the margin of error to the age determined by the doctor on radiological or ossification examination. The appeal was filed questioning the conviction of the appellant for the offences under Section 5(1) read with Section 6, which deals with punishment for aggravated penetrative sexual assault of the POCSO Act, and Section 363 of IPC, which deals with punishment for kidnapping. The bench of Justice K. Surendra observed that there was no conclusive proof regarding the age of the victim, and so the benefit of doubt was extended to the appellant as the prosecution failed to prove the victim's age. The appeal was accordingly allowed. A Delhi court on 15 July granted bail to co-founder of Hot News, Mohammad Zubair, in the Delhi FIR registered against him recently for allegedly hurting religious sentiments and promoting enmity through his tweet made in the year 2018. Additional Sessions Judge Devendra Kumar Jangla of Patiala House Courts granted bail on the condition of Zubair furnishing a ₹50,000 bond with one surety and not leaving the country without the permission of the court. Zubair was arrested on June 27 under Section 153 A and Section 295 of the Indian Penal Code. With this, we've come to the end of today's episode. I appreciate you joining us for this weekly newscast. I am Tanya Pandey for Live Law and you're watching Courts This Week. Have a wonderful day.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.